What we know is a drop. What we don't know is the ocean.
Hello, and welcome to the Newton Knowledge Podcast. My name is Mark Singer, partner of Newton One Advisors, and I'm joined by our managing partner, Steve Target. The Newton Knowledge Podcast will provide meaningful content to our valued advisor community. Our discussions will deliver unique insights into the people, processes, and products that make our industry so critical. Newton One is a national life insurance planning firm delivering customized solutions structured to help clients and their advisors engaged in solving estate planning, wealth transfer, business succession, and executive benefits challenges. We are a member of the M Financial Group, which grants our clients access to the nation's elite carriers and exclusive products available only through our network. Today, we're joined again by Colin Devlin, who is a partner with Lex Nova. Colin joined us for our November 7th, 2023 podcast to review buy-sell planning and funding, as well as fact patterns of the Connelly case at the time. Since then, this case was presented to the Supreme Court on June 6th, and the Supreme Court released its ruling. I think it would be best for our audience, Colin, if you could provide a quick summary of the fact pattern for this case to provide the general background of what's going on here.
Sure. So, Mark and Steve, it's nice to see you guys again. The Connelly case centered around the valuation of a small family-owned business. There were two brothers, Michael and Thomas. They were the sole shareholders of a building supply company. They had entered into a buy-sell agreement that essentially gave the surviving brother the option to buy out the deceased brother at the first brother's death. If the survivor didn't exercise the option, then the company was required to redeem the decedent shares using life insurance proceeds. So Michael passes away. Brother Thomas chooses not to exercise this option, which ultimately triggered the company's obligation to redeem the shares. The life insurance proceeds were $3 million. The company redeemed. The executor of the estate then reports on Michael's federal estate tax return the shares value at $3 million. However, the IRS contests that valuation, comes back and values the shares at more than $5 million, arguing that the life insurance proceeds were to be included in the company's valuation. This resulted in additional estate tax of approximately $900,000. Back in 2022, the Eighth Circuit actually agreed with the IRS, which ultimately led to this case being heard by the Supreme Court. And the Eighth Circuit's, the basis for the ruling was they had taken issue with the fact that the Connelly brothers ignored the valuation provisions of their buy-sell agreement during their lifetime, and that the agreement itself failed to establish a fixed or determinable price, which is required by Section 2703 of the Internal Revenue Code and existing case law.
Colin, there's aren't there cases from 20, 25 years ago that basically validated the non-inclusion of that life insurance policy in a taxable estate? I mean, it's not like everybody just made this up and this is planning that hasn't been validated or played out in the courts previously. So tell us, go back even further, if you will, to that original case, which then led to much of the planning that all of us have done in with our clients for many, many years.
Yeah, sure. So there was another court of, I believe it was in the 11th Circuit, the Blunt case, which is the case that essentially ruled that the redemption obligation had an offset equal to the value that was due from the life insurance proceeds. So essentially, you have the Eighth Circuit in 2022 in the Connelly case directly conflicting with the 11th Circuit Blunt case from many, many years ago. So that's where it really became the Supreme Court's job to ultimately decide, which case was in fact the correct ruling.
All right, so let's talk about that. Let's now go to the Supreme Court and where we are as of, I think Mark's date was right. Wasn't it June 6th of this year?
Yeah, it was earlier this month.
Yeah.
So about 3 weeks ago, to the surprise of many, the Supreme Court unanimously affirmed the Eighth Circuit's decision in Connelly, ruling that a corporation's contractual obligation to redeem shares does not reduce the corporation's value for estate tax purposes. In fact, there is no offset for a corresponding reduction in business value due to the redemption obligation. Now, the Supreme Court's decision is a narrow holding. If the 2703 requirements and existing case laws elements are met, a properly drafted buy-sell agreement can actually fix the value of the business for estate tax purposes, and this holding will not apply. We covered the 2703 elements on the previous podcast at the end of last year, but just to discuss them again, essentially there's three elements under 2703. The first, it has to be a bona fide business arrangement, which is pretty black and white. The second element, which is really the important one, is that it can't be a device to transfer property to heirs or members of a decedent's family for less than full and adequate consideration. With respect to a family-owned business, it can be really difficult to satisfy all the requirements of Section 2703, specifically, proving that the buy-sell agreement itself isn't a device just to transfer wealth, for potentially cents on the dollar with respect to a business. As far as, some of the suggested action, the first step I would recommend to anybody who's a business owner is pulling out your current buy-sell agreement that you most likely had drafted upon formation of the company. Review and update those agreements with your attorneys, your tax advisors, and really make sure that they align with current laws and court rulings. I'd also suggest seeking a professional up-to-date valuation for your company to understand the potential tax impacts and ensure compliance with, current market values and tax regulations. The other thing is, in the case of a family-owned business, I really think a buy-sell agreement, given the recent holding in Connelly, it's really a lot safer to structure a buy-sell agreement as a cross-purchase agreement instead of an entity redemption agreement. Many practitioners, feel that the 2703 requirements could be much easier to meet in a business with unrelated owners, but where you do in fact have a family-owned business, the safer approach is to go the cross-purchase route.
You mentioned cross-purchase as a viable option. What about using an insurance LLC structure to own the policies?
Sure. So another alternative to the cross-purchase agreement would be the insurance-only LLC. So long as the business owners are partners in the insurance LLC, a properly structured transfer of the corporate-owned policies could be a viable option. If it's drafted properly, it can fall within one of the safe harbors, specifically the partnership exception to the transfer for value rule. I think we touched on it, at our podcast at the end of 2023, but, another benefit to the insurance LLC is that it can be much more cost effective than the cross-purchase agreements, because you can limit the number of policies that, would be required in, your typical cross-purchase relationship.
When I think of this, it makes me wonder what could be impacted in regards to other insurance policies that are owned by the business, but not necessarily there for buy-sell purposes, such as key person and other arrangements like that. How will this impact those types of policies?
Yeah, I think that's a really good question, Mark. And to answer your question directly about key person funding, I think any company or business owner that has key person insurance involved, I think the safe play now is to make sure that any key person life insurance is owned by the non-insured shareholders, to avoid inadvertently inflating the value of the company for federal state tax purposes. There really could be some unintended consequences for the business owner who thinks that they're given the golden handcuffs or providing a benefit to their key person or their key people, when in reality it could really adversely impact themselves and ultimately their family.
In moving forward, are there any other suggestions you think? It's funny, towards the end of our last podcast, I feel like we talked about, how could a business deter from this happening, this decision, and everything you just went over are ways that business owners can. But is there anything you can think of that we may have missed that business owners should keep top of mind to deter from something of this significance to happen to their own estate?
Yeah, this may sound rather obvious, but I think the number one suggestion is to make sure the shareholders are actually following the agreement and adhering to the valuation clause and the four corners of their document. With heightened IRS scrutiny, shareholders just can't shoot from the hip. The mere existence of the agreement just isn't enough. The one thing with Connelly is, the two brothers who I think got along very well, there were handshake deals and they acted very informally. The agreement called for an annual valuation. Some may say, well, the cost of a professional valuation each year, may be cost prohibitive. And I would say, well, even if the agreement calls for an annual value, at a minimum, I'd have the shareholders or the board of directors, whatever the agreement calls for, actually document or acknowledge the fair market value of the company each year. I just think it's vital to maintain detailed records of all your agreements, not just your buy-sell agreements, but your corporate books and records, any valuations you have, anything that may suggest or alter the value of the company. any transactions between owners and shareholders, any records that could help you support potentially position in the case of a dispute with the IRS.
This has kind of turned all of our worlds upside down because we've practiced one way for many years, and now we need to at least raise the awareness. And I think that's hopefully what we're gonna help do today is get out to our community and whether they're other advisors that we work with or our clients, and make sure that everybody picks up the phone and has a conversation, reviews the documents, as you said, Colin, because this, the implications, if not properly planned, can be pretty severe here. So we just want to make sure that our folks out there know about this and hopefully reach back and ask the right questions.
Yeah, and not just analyzing the current documents that are in place, but it's probably more your world, Mark and Steve. But just I'd like to highlight the importance of also evaluating the insurance policy itself, making sure that it's adequately valued and it's structured. The product is structured in a way to avoid unexpected tax liabilities.
All great points. Thank you for your time, Colin, on such short notice. It's greatly appreciated, and we truly value the partnership we have between each of our firms.
Thanks, guys. Always a pleasure.
Bye. Goodbye.
The material and opinions voiced are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine what is appropriate for you, please contact a member of our team.